After an accusatory instrument, it's a warrant of arrest or a summons. But before an accusatory instrument is filed, it's an arrest without a warrant or an appearance ticket. Article 100 is the commencement of the action, and it says a criminal action is commenced by filing an accusatory instrument with the criminal court, or filing, or in the case of a juvenile offender or adolescent offender, other than an adolescent offender charged with only a violation or a traffic infraction, with the youth part of the superior court. So you can commence an action by filing the accusatory instrument in a criminal court, or if it's a juvenile offender or adolescent offender, you can file it with the youth part of the superior court. And then it says the only way a criminal action can be commenced in a superior court, other than the action against the juvenile offender or adolescent offender, is with the grand jury filing of the indictment against the defendant never been held by the local criminal court. Good?
Good.
Keep going? Want me to keep going?
Yeah, just keep going.
Okay. Effective October 1st, 2018, 100.60. The youth part of the superior court accusatory instruments, where is that filed? Any youth part or of the superior court accusatory instrument may be filed with the youth part of the superior court of the county when offense allegedly committed or a part of such court has jurisdiction. Effective October 1st, 2018, 100.10. Methods of requiring a defendant's appearance in a local criminal court or youth part of the superior court for arraignment. So we're talking about local criminal court or youth part of the superior court. After an action is commenced by filing the accusatory instrument in the local criminal court or in the youth part of the superior court, a defendant who has not been arraigned may be compelled to appear by either a summons or a warrant of arrest. And if no criminal action has been commenced yet, the defendant may be compelled to appear by either arrest without a warrant or an appearance ticket. So the warrant of the arrest is a local criminal court or a youth part, but the superior court warrant of arrest is a superior court.
Warrant of arrest.
Warrant arrest, right. Didn't I say that? Superior court warrant of arrest is for superior court, and a regular warrant of arrest is for local criminal court and youth part.
Yep.
Warrant of arrest is for the purpose of arraignment. A bench warrant is after arraignment.
For some other purpose.
Some other purpose, right. 120.10, warrant of arrest must have 6 things. The warrant of arrest must have 1, the issuing court, 2, the date of the warrant, 3, the name or the title of the offense charged, 4, the defendant's name, 5, the police officer who warrant is addressed to, and 6, a direction to bring the defendant to court. Effective October 1st, 2018, 120.20, warrant of arrest, when issuable. When the action is commenced in the local criminal court or the youth part of the superior court by filing the accusatory instrument other than a simplified traffic information against the defendant not arraigned yet and hasn't come under the control of the court may if the accusatory instrument is sufficient, the court may issue a warrant of arrest. If the accusatory instrument is not sufficient, the court may dismiss the accusatory instrument. Or, even if the accusatory instrument is sufficient, the court may refuse to issue the warrant until satisfied by inquiry of witnesses that there's reasonable cause that the witness may be examined under oath or otherwise. Or, if a summons may be issued in lieu of the warrant, the court is satisfied that the defendant will respond. It may not issue a warrant of arrest and issue the summons, or upon the request of the district attorney in lieu of the warrant of the arrest or the summons, the court may authorize the district attorney to direct the defendant appear, just to direct him to appear. So once again, effective October 1st, 2018, 120.20, it's the warrant of the arrest when it's issuable, and it's issuable after the filing of an accusatory instrument, except for that simplified traffic information. And it has to be when the defendant has not been arraigned. And the court may either issue a warrant of arrest or may dismiss the accusatory instrument, or if the accusatory instrument is sufficient, the court may refuse to issue the warrant of arrest until it's satisfied from inquiries of witnesses that there's reasonable cause to believe, or issue a summons in lieu of the warrant arrest, or instead of issuing the summons or the warrant, at the request of the DA, direct the defendant to appear. Effective October 1st, 2018, 120.30, warrant of arrest issued and returnable. A warrant of arrest may be issued by who? Two people. The warrant of arrest may be issued by the local criminal court
Or the youth part of the Superior Court.
Part of the Superior Court. Bingo. Where the accusatory instrument is filed and may be returnable in such issuing court only. Effective October 1st, 2018, 120.55, warrant of arrest, under parole or probation. If a defendant named in the warrant of arrest issued by a local criminal court or a youth part of the Superior Court, or if an indictment was filed and it's issued as a Superior Court warrant of arrest, is under the supervision of the State Department of Corrections and Community Supervision or local state probation department, then the warrant may be executed by a parole officer or a probation officer when authorized by the defendant's probation director. Effective October 1st, 2018, 120.70, warrant of arrest where executable. Warrant of arrest issued by. So the warrant of the arrest could be issued by 1, the district court, 2, the New York City Criminal Court, 3, the youth part of the Superior Court, 4, the Superior Court judge sitting as a local criminal court. Got that? Warrant of arrest issued by district court, New York City Criminal Court, youth part of the Superior Court, or a Superior Court judge sitting in the local criminal court, and it may be executed anywhere in the state. If the warrant of arrest is issued by a city, town, or village court, it may be executed in the county of issuance or adjourning county, or anywhere else in the state upon written endorsement of local criminal court arrest to be made. When endorsed, the warrant is deemed the process of the endorsing court and issuing court. 160.10, fingerprinting duties of the police. Following arrest or arraignment, arresting officer or appropriate officer or agency must take fingerprints if defendant is charged with 1, a felony, 2, a misdemeanor in the penal law, more than 15 days, but no more than 1 year, 3, a misdemeanor outside of the penal law, which would constitute a felony if the defendant had previous conviction of the crime. And 4, loitering as for prostitution, penal law 240.37. So that's when the police officer must take the fingerprints. Felony, misdemeanor in the penal law, misdemeanor outside the penal law for a crime that would constitute a felony, and loitering for prostitution. When the officer may take fingerprints with or without a warrant is three reasons: when they're unable to ascertain the identity, when reasonably suspect's identification given is not accurate, and when reasonably suspect's person is being sought after by the law enforcement for other offenses. So they must take fingerprints when it's a felony, misdemeanor in, misdemeanor out, or loitering for prostitution, and they may take fingerprints if they're unable to ascertain the identity, reasonable suspects the identification is not accurate, or reasonable suspects that the person is wanted by law enforcement for other offenses. Whenever fingerprints are taken, the photograph and palm prints of defendant may also be taken. That's a may. 160.20, fingerprinting forwarding. Upon taking the fingerprints, the appropriate police officer or agency must, without
Unnecessary delay.
You should just scream out the answers.
All right.
Forward 2 copies to the DCJS Division of Criminal Justice Service. And then it says 160.30, fingerprinting DCJS duties. Upon receiving the fingerprints, the DCJS must do 3 things.
Promptly.
1, classify them.
File them.
2, search their records for previous records of the defendant, including any adjudication as a juvenile delinquent or youthful offender. And 3, promptly transmit to such officer or agency a report. Such report, if certified, constitutes presumptive evidence of the fact so certified. So the DCJS receiving the fingerprints must classify them, search their records, and promptly transmit them back to the officer with a report.
With the report.
Right? Okay. And if the fingerprints received are not legible, they must be returned to the officer or agency with an explanation of the defects and request defendant's fingerprints be taken again if possible. 160.40, fingerprinting, transmission of the report by the police. The DCJS sends the report to the police officer or the agency. The police officer of the agency and the agency who gets the reports must promptly send the report or a copy of
to the court.
One to the DA of the county and 2 to the court. Right. The court is now going to furnish the report to 1 to the counsel for the defendant, and if not, the defendant is not represented, then 1 to the defendant. So just going over that again, the DCJS makes the fingerprints in the report, sends that to the police. The police promptly send 1 copy to the DA and 2 copies to the court. The court sends the report to the counsel for the defendant or the defendant. And no district attorney, police officer, or law enforcement agency shall request or require a victim of sexual assault to submit to a polygraph or psychological examination. 160.50, order upon termination of a criminal action in favor of accused. Upon termination of an action in favor of the accused, unless the district attorney, upon motion, with not less than how many days?
5 days. 5 days.
You're good. Not less than 5 days notice to the defendant's attorney, demonstrate to the satisfaction of the court that in the interest of justice require otherwise, that they shouldn't terminate in favor of the accused, I guess.
That they shouldn't be sealed. They shouldn't be sealed.
Oh, this has to do with sealing?
Yeah.
Oh, I didn't get to that part yet. That's right. I'm sorry.
That's all right. Keep going. You're good. You're doing amazing.
Okay, great. Unless the district attorney, upon motion with not less than 5 days notice to the defendant or the defendant's attorney, demonstrates to the satisfaction of the court that the interest of justice require otherwise, or the court on its own motion not less than
5 days
notice to the defendant and his attorney determines that the interest of justice require otherwise and states the reasons for determination on the record, the court record of such action shall be sealed, and the clerk of the court shall immediately notify 2 people. Who are the 2 people?
DCJS and the heads of all appropriate police departments.
Ding, 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 ding. And that the records shall be sealed. And upon receipt of notification of such sealing, every photograph, photographic plate, proof, palm prints, fingerprints, duplicates, copies, except for digital fingerprints, shall be returned or destroyed at the discretion of the recipient's agency. What do they do with the digital ones?
They save them.
Okay. Upon receipt of notification of such sealing, any police department, law enforcement agency, or DCJS that transmitted anything shall request in writing that all copies be destroyed or returned to the agency that sent them. And if returned, such police department agency shall destroy them or return them. All other records and papers, judgments, and orders of the court, but not published decisions or opinions, or records and briefs on appeal, shall be sealed and not made available to any person or public or private agency. I'll repeat that again. All other records and papers, judgments, and orders of the court shall be sealed and not made available to any person or public or private agency, but not published decisions or opinions or records and briefs on appeal. I guess those should not be sealed. Is that what that's saying?
Well, they've already been published, I guess, so.
Right, so that's...
What are you going to do about it?
Okay. 160.55, order upon termination of a conviction for non-criminal offenses. Non-criminal offenses means what?
That means you pled guilty to a violation, or like it was a DWI reduced to a traffic infraction. And there's the biggest difference between 160.50, 160.59, and 160.58. Those are all in the same...
This is 160.55.
I know. Those three that I just named, those are in a different category than 160.55. And the reason is because 160.55, the court record is not sealed. I have a whole video on this where I'm yelling at all these clerks everywhere.
160.55 is not a sealing?
It's a sealing only of the police record.
Sealing.
Partial
It's a partial
sealing.
sealing.
Yes, only
I do
of
this
the police,
at work.
Yeah, only of police records.
It's a partial sealing. Okay. So upon termination of an action by conviction for a non-criminal offense, that's a violation, right?
Hold on, I just gotta shut the door because it's gonna be
Okay.
noisy on the video. Hold on. All right, go ahead.
So that's a violation,
Yep.
right?
Yep.
Upon termination of the action by conviction, so he's been found guilty of a violation,
Or
right?
a traffic infraction.
It says here, conviction of a one in traffic infraction or a violation other than loitering or operating a vehicle while impaired, unless the district attorney upon not less than how many days' notice
5 days.
demonstrates to the court satisfaction that the interests of justice require otherwise, or the court on its own motion not less than
5 days notice.
notice determines that the interest of justice requires otherwise. The clerk of the court shall immediately notify who?
DCGS and the heads of all appropriate police departments and agencies.
Right, that such action has been terminated by such conviction. That's what I have on Article 100. I thought that was pretty good, right?
Okay, the only thing is you're on Article 100 or 160?
That was 100, but maybe I had 160 questions missed in there. But I'm going right now to 170.
Okay, so there's 2 more sections in 160.50. I'll just tell you briefly what they are.
Okay, tell me, and then we'll go to 170.
Okay, so there's 160.58 and 160.59, and both of those have to do with sealing. One of them is about sealing after 10 years. You can come in and make an application to have...
So which one is that, 58 or 59?
I don't recall exactly.
All right, okay.
But just know that there's one about a 10 years...
10 years.
Sealing. That one would seal the court record and the police record. Then the other one is for a drug case, which where it can be conditionally sealed.
Okay.
So just be aware that those two exist. One is about 10 years later. They can come in and ask for it. So
now I'm going to read through 170 really fast like I've been doing.
All right. And do you have questions on this?
You yell out. These are all questions.
All right. So pause when I'll try to yell out the answer.
And yeah, I pause when you yell out the answers. And if you can't get it, I'll say the answer and read the question again with the answer. And then we'll move on. And we'll just make fast videos like that.
Yeah. I mean, I'm recording this whole video. I'm not even going to edit it.
Yeah. You have to send these to me. Can you send them to me in one full clip, or you have them on your YouTube?
I'm going to have them on the YouTube. I'll send you the link.
Okay, that's fine.
Okay.
Label them too, like 170, 180, when we do it. Can you do that?
I was just going to put all criminal.
Oh, okay. Well, this is all 170, so maybe you might
All right, so I'll start a new video. So let me start a new video then.
Yeah, because this is let's just do separate.